You know deep down in your heart that your doctor violated the basic standards of medical care. I know, after doing a thorough investigation, that your doctor violated the basic standards of medical care. Why won't the defense come right out and admit that they violated the basic standards of medical care? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. Now remember, when you bring a lawsuit seeking compensation for the harms and losses you suffered because of a doctor's carelessness, the defense has an opportunity to defend themselves. They will hire an attorney to go ahead and mount a defense. They're not going to automatically roll over and put their hands up and say, "You're right, we give up. You were right, we're wrong." That's not what they do. Instead, the insurance company hires a defense attorney who now is going to represent the doctor in this medical malpractice case. The first thing the attorney is going to do is turn around and say, "We didn't do anything wrong. But if we did something wrong, it's not as bad as you think it is." And now they're going to do everything possible to show, ultimately during the course of your lawsuit, that number one, your credibility is garbage, that you are a liar. And number two, they're going to show that they did nothing wrong, and even if they did something wrong, and now they have to talk about damages and the injuries that you suffered, they will do everything possible to try and minimize the damages that you have suffered to ultimately show to a jury that, listen, what the plaintiff and the injured victim is showing here is not as bad as you think it is. And here's why. So the defense has a clear agenda. They are not going to turn over, they're not going to roll over and simply throw their hands up and says, "You're right, counselor, we admit it, we did something wrong, now let's finish it up, we'll give you whatever you want." That's not the way it works. They have an agenda, and their agenda is, number one, deny it. Number two, if they do have obligations to repay, minimize whatever value there is. So why do I share this great information with you? I share it with you just to give you an insight and an understanding to what goes on in the litigation process in a medical malpractice case here in the state of New York. You might be contemplating bringing a case and you're wondering how the process works and what goes on. You think something was definitely done wrong. I know something was definitely done wrong. The defense attorney may know something was done wrong, but he's not going to come to you and say, "You're right. Let's pay up right now because you're absolutely right." Instead, they're going to drag out the litigation process, they're going to make you jump through hoops, and then maybe toward the end or at the end as your case goes to trial, that's when they may turn around and start talking and negotiating with you. You know, I realize you're watching this video because you have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.